Can you what the challenges first arises in the enforcement of these arbitral awards that involves non-signatory, and also can you provide some examples of cases where non-signatories actually were successful indeed, and what legal principles were applied?
So the classic issue that arises in award recognition contexts is under Article 5.1a of the New York Convention, or Article 34.2a1 of the UNCITRAL model law in an annulment, a set-aside context. Both those two sets of provisions allow for either annulment on the one hand or non-recognition of an award on the other, where there was no valid agreement to arbitrate. And what does it mean not to have a valid agreement to arbitrate? It means a valid agreement between the parties who are bound allegedly by the arbitral award. And so if a non-signatory is the respondent in a case, unsuccessfully challenges before the arbitral tribunal its participation in the arbitration, says, I'm not bound by the arbitration clause, tribunal should dismiss the arbitration against me. Tribunal refuses. Tribunal says, you're an alter ego, or you're a principal that is bound by the agent's acts, and makes an award against this party. That party then can argue in a subsequent annulment or recognition proceeding, I wasn't a party to the arbitration agreement. I didn't sign it. I'm not bound by it. The award can't be recognized against me. It must be annulled because there was no valid arbitration agreement that bound me. And courts in a number of cases have accepted that conclusion. A good example, you asked for examples, is a classic Swiss case involving Westland Helicopter on the one hand, and then a consortium of Middle Eastern countries, including Egypt, on the other hand. And the consortium members, the countries, the nations that were parties to the consortium, said that they hadn't signed the arbitration agreement. They were non-signatories. And the question was whether or not they would be bound by an award. The tribunal rejected that argument, by an award. And the Swiss Federal Tribunal ultimately, after fairly lengthy proceedings, concluded that they would not be bound, that the non-signatories were not bound by the award that had been made against them.
Interesting.